So, hi. Pag-uusapan naman natin ngayon yung executive department. No? So, the President of the Philippines, kasi sa kanya vested yung executive power solely. Kahit marami siyang mga sangay-sangay, really, it's a one-man department and all others are just his alter egos. You know, just a comment before we start discussing. When you're a law student or a lawyer or in the legal profession, there's really no room for opinions, like your personal opinions. Like, it's good that we're passionate about politics, for example. Pero we can't be too opinionated kasi it might cloud our judgment in the way, like for example, we answer bar questions or answer recitations or just doing our jobs. Like for me, for example, I'm a legal associate, so there's really no room for personal opinions. Like for example, yung controversial case ng involving late President Marcos and the libingan ng mga bayani, his internment sa libingan ng mga bayani. A lot of people disagreed with the Supreme Court's decision nila, di ba? They had strong opinions about it. But, there's really nothing we can do about it. The judicial department, they interpret the laws. If they interpret it a certain way or they have that opinion, then there's really no choice but to interpret the law that way and to abide by the Supreme Court decision, because it is what it is. It is the law according to them. Like, while their opinion may change until then, how they interpret it is our basis. We can't substitute our own personal opinions sa opinion ng Supreme Court. Same with the law. Like, if may times that we disagree with a certain legislation, there's really nothing we can do about it because it is the law. We're not lawmakers. So if there is a legislation na hindi natin gusto, but it's not unconstitutional, it's not declared unconstitutional, then there's really nothing we can do about it. But yun talaga yun. Unless and until ma-declare siya na unconstitutional, yun yung susundin. Diba? So, I guess if you're a law student or a lawyer or a legal professional, it's best to be, kind of neutral sa politics and not to be too opinionated, or else we won't be able to do what is expected of us. So anyway, executive department, executive power. It is the power to enforce and administer the laws, and it is vested in the President of the Philippines. So, na-touch on naman natin to when we were discussing the other concepts in CONSTI and when we were discussing legislative department. Because again, there are 3 branches of the government, and the legislative is in charge of making the laws, the president is in charge of executing, implementing, enforcing, administering the laws, while the judiciary is the interpreter of the laws. So first, let's go to the qualifications of the president and vice president kasi parehas lang naman. First, natural-born citizen of the Philippines. Second, at least 40 years of age on the day of the election. Third, able to read and write. Hindi kailangan college graduate, hindi kailangan high school graduate. Kailangan literate lang. Next is that he or she must be a registered voter, of course. Doesn't matter where, kasi national level naman yung presidency. And resident of the Philippines, anywhere in the Philippines, for at least 10 years immediately preceding such election. The Vice President may be appointed as a member of the cabinet by the President, and such appointment requires no confirmation. But really, the role of the Vice President is to wait for the President to be incapacitated or to die or to get impeached para siya yung substitute, para hindi ma-paralyze yung government, because the role of the President is very important. So, para siyang reserve President. However, diba, kasi nakatenga lang siya dyan, the Vice President may be a member of the cabinet, which is the case kay Vice President Sara Duterte ngayon. She was appointed, I think, sa DepEd. Is that right? I'm sorry, I don't follow current events that much, but yeah, ganon. Kapag hindi mo kapartido, of course, pwedeng hindi ka niya bigyan ng, yung president, kapag hindi kayo tandem, pwedeng hindi ka niya bigyan ng cabinet position. Such as what happened sa kay Duterte and kay Leni Robredo. So, anyway, election for president and vice president. The regular election happens second Monday of May every 6 years because the term of the president and the vice president is 6 years. However, there is a special election that is upon first the death or permanent disability or removal from office or resignation of both the president and the vice president. Kasi wala na uupo. Although, i-discuss natin yung succession na merong temporary na uupo dyan. If the vacancies occur more than 18 months before the next regular presidential election. Kapag yung vacancies, like for example, walang president, walang vice president for some reason, pero 18 months na lang, like within that period, 18 months or less na lang, may next regular presidential election na hindi na kailangang magpa-special election kasi magastos yan eh. Hintay na lang. Total, meron namang rules on succession yan na may uupo dyan talaga. And a law is passed by Congress calling for a special election to elect a president and vice president to be held not earlier than 45 days and not later than 60 days from the time of such call. That is, if the vacancies, again, do not occur more than 18 months before the next regular presidential election. So, Congress as canvassing board. The proclamation of presidential and vice presidential winners is a function of Congress and not of the COMELEC. Congress may continue the canvass even after the final adjournment of sessions. Adjournment terminates legislation, but not non-legislative functions of Congress such as, of course, canvassing of votes. The function of Congress is not merely ministerial. It has the authority to examine the certificates of canvass for authenticity and due execution. For this purpose, Congress must pool a law governing their canvassing function. The Supreme Court acts as the Presidential Electoral Tribunal or the PET. The Supreme Court sitting en banc shall be the sole judge of all contests relating to the election, returns, and qualifications of the president or vice president, and may promulgate its rules for the purpose. So the PET, as intended by the framers of the Constitution, is to be an institution independent but not separate from the judicial department. So hindi COMELEC kapag ka na-elect na, magiging PET na. And yung canvassers, not yung COMELEC, but yung Congress. However, yung COMELEC, merong jurisdiction before may na-declare na nanalo. However, kapag may mga contests, may mga kaso, after there's a declaration, then it is the Supreme Court that acts as the Presidential Electoral Tribunal and not COMELEC. Why? Because it's the highest office of the land and it's vested in one person. So, it's really a big deal. Oath of office. So before entering on the execution of their office, the president, vice president, or the acting president even shall take the oath or affirmation. Oath is when you are invoking God, like it's an outward pledge made under an immediate sense or responsibility to God. That is if the president or vice president is a religious person or a believer of a God. It is not source of substantive power. However, like we don't unlike for example in UK where they have the Church of England, and the source of power really of the monarchy is from direct from God. We don't have it here in the Philippines. You're very secular. So it's not a source of substantive power. The power comes from the people who elect the president. This oath is just intended to depend on the sense of responsibility of the president and ensure a more conscientious discharge of his or her office. Kasi kapag believer siya or religious siya, there's like that sincerity and that parang kung believer siya, edi mas may weight yung oath niya. However, if non-believer naman yung president or vice president, and can take an affirmation, which is just a solemn declaration in place of that of an oath. Okay. So, term of office. Again, the president and vice president shall be elected by direct vote of the people for a term of 6 years. That's why we have an election every 6 years. And the president shall not be eligible for any re-election. Just the president. Of course, the vice president can aim for higher office, which is presidency. Or being vice president again. No person who has succeeded as president, however, and has served for more than 4 years shall be qualified for election to the same office at any time. However, if less than 4 years naman, gaya ng kay Gloria Macapagal Arroyo, then that's fine. Kasi diba VP siya, and then nag-serve siya sa term ni ERAP, and then nag-run pa siya ulit. Kasi hindi naman siya nakaserve ng more than 4 years. No vice president shall serve for more than 2 consecutive terms. So again, the vice president can run again for the same position and be vice president. However, it can only happen like consecutively 2 times. Meaning, pwede rin siya namang magpahinga. Hindi pwedeng more than 3. Like for example, hindi pwedeng more than 1 rather. For example, nag-serve na siya as vice president ngayon. For example, Sara Duterte is a vice president now. So next election, she can still run for the same office, which is, the office of the vice president. However, sa succeeding election, bawal na. She can either run as president or another office, but not the office of the vice president anymore. Because 2 consecutive terms lang yung allowed. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which was elected. So, for example, si Sara Duterte, vice president ngayon, tapos nag-resign siya, so vice president ngayon, tapos nag-run siya for the same office the next election, so 2 consecutive na yon, pero yung sa second niyang term, hindi niya tinapos, nag-resign siya, pwede ba siyang mag-run sa next? Hindi, kasi counted na yun as like part of the 2 consecutive terms, even if hindi na-serve out entirely. So now let's talk about the privileges of the president. First is of course presidential immunity. The president during his tenure of office or actual incumbency may not be sued in any civil or criminal case because again, as explained, impeach muna siya, tanggalin muna siya. And pag natanggal na siya through impeachment, then masished na yung immunity, then vulnerable na siya. But until then, merong immunity. Because yung purpose niyan is ayaw nating maharas yung president with cases here and there by his or her political enemies, for example. So, hindi niya na magagawa yung duties niya, which is very important, granting that it's the highest office of the land. And while it is the highest office of the land, let's not forget that the departments are co-equal. It's just that it becomes the highest office of the land kasi hindi siya part of a Congress. Hindi siya part of a college. Like, what do you mean by that? Hindi collegiate, unlike Supreme Court, wherein 15 sila dyan, although headed by the Chief Justice, but the power is not solely vested in the Chief Justice, but in the Supreme Court as a whole. Same with the Congress. Like, upper house or Senate has the Senate President, Speaker of the House in the case of the lower house, or the House of Representatives. They're not the leaders. They're not they don't wield the power singly. Rather, they act as a body. Like, Senate cannot even be considered as the Congress alone because it needs the House of Representatives, and the House of Representatives, even called the quote-unquote lower house, has a power of the purse actually kasi sa kanila nanggagaling yung budget, for example. So, Congress, the legislative power, yes, from the people, given to the delegated to our lawmakers, no, they act as a body. They can't act like as a singular, like for example, a senator there or a congressman there really doesn't have the power unless, his power is nandon as a group sila. However, in the case of the executive department, it's just vested in one person. That's why it's considered as quote-unquote the highest office of the land kasi sa kanya lang lahat eh. So, buong department kanya, isang tao lang. Although co-equal lahat, pero isang tao lang siya. The presidential immunity from suit remains preserved under our system of government, albeit not expressly reserved in the present constitution. So again, the ratio is that the grant to the president of the privilege of immunity from suit is to ensure the exercise of presidential duties and functions free from any hindrance or distraction, considering that being the chief executive of the government is a job that, aside from requiring all of the office holders' time, also demands undivided attention, not to mention that he's also the commander-in-chief of the AFP. So the presidential immunity pertains to the president only, not to the vice president, by virtue of the office, and may be invoked only by the holder of the office, not by any other person in the president's behalf. Thus, an accused in a criminal case in which the president is complainant cannot raise the presidential privilege as a defense to prevent the case from proceeding against such accused. So it may prosper dun sa co-accused but not to the president because it's personal. The immunity is personal. Moreover, there is nothing in our laws that would prevent the president from waiving that privilege. So, for some reason, kung gusto niyang i-waive, then i-waive niya. But, ang labo na i-waive niya. Kasi pabor sa kanya yung immunity eh. Malay mo. The presidential immunity has no application to the president's subordinates. Of course, again, it's personal. After his tenure, the president can no longer invoke immunity from suit. That is why the proper way, if you really want to oust the president and to file cases against him, is to wait until the term is over and then tambakan nyo ng kaso yan. Kasi wala nang immunity. It comes with the office. It's not forever. Once you're not president anymore, you don't have that immunity anymore. It doesn't stick to the person. Rather, it sticks to the office. So while you're sitting at the office, you're untouchable. But once you lose the office, you become vulnerable. So another way is to impeach. First, impeach means you remove from office now that the person or the president is separated from the office of the president, so he's no longer president, then he is vulnerable and cannot invoke presidential immunity. So again, it attaches to the president by virtue of the office during the entire tenure of the president. Tenure, not term, because term is like 6 years. Tenure is the actual stay, diba? So it could be na parang si Erap, like, did not serve the entire term. The tenure was only like 4 years? No balancing of interest has ever been applied to presidential immunity under our jurisprudence. It's unquestionable. Immune siya. There's no, for valid or justifiable reasons, pwedeng i-disregard yung immunity. No, it's like all cases. Immune siya as long as nakaupo siya dyan. Such great power, such great privilege. Executive privilege is different from presidential immunity. Executive privilege is the right of the president and high-level executive officials, so hindi lang sa president but also high-level officials, to withhold information from Congress, the courts, and ultimately the public. And I think we just discussed this a previous video. It's because of the operational proximity then, which is different from executive privilege of course, because executive privilege comes with a position, like for example, if you're a department head or something, not just like, because operational proximity can be invoked by anyone by anyone na has that information by virtue of like what was discussed in the closeness, the proximity to the president, could be an advisor or something. But for executive privilege, it comes with a position that is naturally close to the president, that privy siya sa certain information that should not be disclosed or divulged to the public. The necessity for withholding the information must be of such high degree as to outweigh the public interest in enforcing the obligation in a particular case. So unlike presidential immunity, where there is no need for balancing of interest, here in invoking executive privilege, because if not invoked by the president, there should be like a justification to withhold. Again, yung president and members of the Supreme Court, for example, in legislative investigation, they cannot be just summoned for legislative inquiry. If they refuse to do so, hindi sila ma-contempt. However, for other officials, they have to have a justification on why they should show up, and if they withhold information, there must be a justification as to why. So a person covered by the executive privilege is a person in possession of information which is in the judgment of the head of office concerned privilege. So sino yung head of office ng executive department? Of course, it's the president. So requisites for executive privilege to be validly claimed by the president. The communications relate to the power to enter into an executive agreement with other countries, which is quintessential and non-delegable power of the president. The communication was received by a member of cabinet, which through a proximity test, again, as discussed before, as previous video, the operational proximity, is covered by executive privilege, and no adequate showing of a compelling need that would justify the limitation of the privilege and of the unavailability of the information elsewhere by appropriating investigating authority. Now, executive privilege covers all confidential or classified information between the president and public officers covered by executive order, including conversations and correspondence between the president and the public official covered by executive order, military, diplomatic, and other national security matters. Again, the president is also the commander-in-chief of the AFP, which in the interest of national security should not be divulged. Information between intergovernment agencies prior to the conclusion of treaties and executive agreements, of course, so as not to preempt discussion in closed-door cabinet meetings and matters affecting national security and public order. Other kinds of executive privilege that could be similar to what was mentioned: presidential communications privilege, deliberative process privilege that includes advisory opinions, recommendations, and deliberations comprising part of a process by which governmental decisions and policies are formulated, diplomatic negotiations privilege. This is to encourage, of course, a frank exchange of exploratory ideas between negotiating parties. So sa part pa lang naman sila ng exploration, hindi kailangan divulge kasi again, baka ma-preempt, di ba? Informers privilege not to disclose the identity of those who furnish information of violations of law to officers in charge of enforcement, and state secrets privilege, which are secrets that, if divulged, could be inimical to national security. So what are the other privileges that comes with presidency that is residing in the official residence for the president, which is the Malacañang Palace? Okay, so I'll make that distinction na Malacañang is the palace, Malacañang is that entire complex in Manila, but the palace itself, it's Malacañang without the G. You put the G if you refer to the entire complex. Salaries of the president and vice president are determined by law and not to be decreased during his tenure, just like, the justices. Prohibitions or inhibitions. No increase in said compensation shall take effect until after the expiration of the term of the incumbent during which such increase was approved, pretty much like sa members of Congress. Their salaries shall not be decreased during their tenure, pero kapag yung increase is in-implement sa time nila or pinasa sa time nila, then kailangan sa next pa siya mag-a-apply para hindi sila mag-benefit dun sa increase. Kasi of course, kung pwede, edi ilalabi nilang i-increase para mag-benefit sila dun. Hindi naman natin gusto yon. Pero hindi madi-decrease. They shall not receive during their tenure any other emoluments from the government or any other source. The President, Vice President, members of the Cabinet, and their deputies or assistants shall not hold any other office or employment during their tenure unless otherwise provided in the Constitution. Like for example, if the Vice President, as mentioned earlier, may be appointed to the Cabinet without the need of confirmation from the Commission on Appointments. So if you want to know about the Commission on Appointments and all that, there's a video na uploaded on about it. The prohibition also does not cover positions that are obtained by ex officio capacity. So, by virtue of the office. Like, for example, madaming ex officio capacity, di ba? Like, sitting at the JBC or Judicial Bar Council, by virtue of the office, mga ganyan. The President, Vice President, and members of the Cabinet shall not directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with or in any franchise or special privilege granted by the government or any subdivision, agency, or instrumentality thereof, including GOCCs or their subsidiaries. Strictly avoid conflict of interest in the conduct of their office, may not appoint spouse or relatives by consanguinity or affinity, okay, mga in-laws, so kadugo and in-laws included, within the 4th civil degree of the President as members of the CONCOM, so in CONCOM, COA, CSC, COMELEC, Office of the Ombudsman, or as secretaries or undersecretaries or chairman or heads of bureaus or offices, including GOCCs and their subsidiaries. The reason is, of course, these inhibitions are in line with the principle that a public office is a public trust and should not be abused for personal advantage. So now let's discuss the powers of the President. Executive power. The President shall have control of all executive departments, bureaus, and offices. He or she shall ensure that laws are faithfully executed. It is the power to enforce and administer the laws, and it pertains to the power to enforce and administer the laws. It's vested in the President and exercised through manifold of offices under the or within the executive department. Administrative power refers to the President's control over all such executive departments, bureaus, and offices. So yung mga department na yan, DepEd, DSWD, DILG, lahat executive department yan. The President shall ensure that laws are faithfully executed. So, faithful execution or take care clause. Unless and until a law is declared unconstitutional, the President has a duty to execute it regardless of his doubts as to its validity. Kasi again, hindi siya yung taga-question kung constitutional or unconstitutional yung batas. Pwede siya mag-file ng case, pero it is ultimately nasa province ng power ng judicial department. And all laws are presumed constitutional unless and until declared otherwise. Power of administrative reorganization. Under Section 31, Book 3 of EO number 292, the President, subject to the policy of the Executive Office and in order to achieve simplicity, economy, and efficiency, shall have continuing authority to reorganize the administrative structure of the Office of the President. The President's power to reorganize the Office of the President should be distinguished from the power to reorganize the Office of the President proper. The power to reorganize the Office of the President proper is done by abolishing, consolidating, or merging units, or by transferring functions from one unit to another. The power to reorganize offices outside of the Office of the President proper, but still within the Office of the President, is limited to merely transferring functions or agencies from the Office of the President to departments or agencies and vice versa. Kasi again, yung mga departments na yan, hindi yan parang basta-basta lang na parang gagawa lang ng committee si President. May batas yan. So, kailangan ng law for it. However, mayroong Office of the President, diba? Na yung Office of the President proper, yun yung mga chief of staff niya, mga speaker niya, yung team niya, kumbaga, sa Office of the President. Yun yung Office of the President proper. Pero technically, yung Office of the President, lahat, executive department. A valid reorganization must not only be exercised through legitimate authority, but it must be also pursued in good faith. Mga typo ako sa notes ko. A reorganization is said to be carried out in good faith if it is done for purposes of economy and efficiency. It is the President's continuing authority to reorganize the executive branch, which includes the power to group or consolidate bureaus and agencies, to create and abolish offices, to transfer functions, to create and classify functions, services, and activities, and to standardize salaries and materials. It is effected in good faith if it is for the purpose of economy or to make bureaucracy more efficient. Next power is the power of appointment. The appointing power to offices of the President. Appointment is a selection by authority vested with the power of an individual who is to exercise functions of a given office. Legislature may not usurp such appointing power of the President. The legislature may create an office and prescribe the qualifications of the person who may hold the office, but it may neither specify who shall be appointed to such office nor actually appoint someone. However, there is no encroachment on the discretion of the appointing authority when the Civil Service Commission revokes an appointment on the ground that the removal of the incumbent employee was done in bad faith. In such instance, the CSC is not actually directing the appointment of another but simply ordering the reinstatement of the illegally removed employee. So appointments requiring the consent of the Commission on Appointments, heads of executive departments, ambassadors and other public ministers and consuls, officers of the Armed Forces of the Philippines from the rank of colonel or naval captain, and officers whose appointments are vested in the President in the Constitution. So only appointments under the first sentence of Section 16 of Article 7 need confirmation of the Commission appointments, those that I enumerated, and the Congress cannot by law expand the list of public officials required to be confirmed by the Commission on Appointments. Officials of the Philippine National Police do not require confirmation by the Commission on Appointments because the PNP is different from the AFP. Yung PNP police, yung AFP yun yung military. Appointments that do not require confirmation from the Commission on Appointments are those, of course, that are not provided by law, and those that the President is authorized by law to appoint, and officers lower in rank whose appointment is vested by law in the President alone. Appointments procedure for those that require confirmation from the Commission on Appointments. So first, may nomination by the President. Second, i-confirm ng Commission on Appointments. Third, pag okay, issuance of commission, and may acceptance ng appointee dapat. So the appointee can refuse. So this kind of appointment is deemed complete upon acceptance. Pending such acceptance, which is optional to the appointee, the appointment may still be validly withdrawn. Appointment to a public office cannot be forced upon any citizen except for purposes of defense of the state, as an exception to the rule against involuntary servitude. In ad interim appointments, all the steps precede the step wherein there is confirmation by the Commission. This step is also skipped when the appointment does not require confirmation by the Commission. So appointments with prior recommendation or nomination by the Judicial and Bar Council. So yung mga mention kong COA, JBC na discuss na yan previously. Members of the Supreme Court and all lower courts, and Ombudsman and his 5 deputies. So kailangan may JBC muna. Magpa-provide ng list si JBC, doon pipili si President. Appointments requiring nominations by multi-sectoral groups, Regional Consultative Commission, and party list representatives before the party list law. Kinds of presidential appointments. We have regular presidential appointments, with or without confirmation by the Commission on Appointments, and recess or ad interim appointments. So such ad interim appointments is a permanent appointment unless otherwise indicated. An ad interim appointment is made by the President while Congress is not in session or during recess. It is made before confirmation of the COA, and such appointment ceases to be valid if disapproved by the Commission or upon the next adjournment of the Congress. So medyo 50-50 pa siya dyan. Pero habang hindi pa, habang recess pa yung Congress, okay pa. Like, for all intents and purposes, hawak na niya. Appointed na siya, pero pwedeng i-disapprove. When the Commission of Appointments disapproves an ad interim appointment, the appointee can no longer be extended a new appointment inasmuch as the approval is a final decision of the Commission in exercise of its checking power on the appointing authority of the President. Such disapproval is final and binding on both the appointee and the appointing power. But when an ad interim appointment is bypassed, hindi na-act on it ng COA because of lack of time or failure of the Commission to organize. When I say COA, I mean, in this context, I mean Commission on Appointments kasi it could mean Commission on Audit, but what I mean here is Commission on Appointments. So, if bypassed, because of lack of time or failure of the Commission to organize, there is no final decision by the Commission to give or withhold its consent to the appointment. Absent such a decision, the President is free to renew the ad interim appointment. This is called a bypassed appointment and is one that has not been finally acted upon on the merits of the Commission appointments at the close of the session of the Congress. We have a 3-strike rule. A nomination or appointment which has been bypassed 3 times shall be reported out by the standing committee concerned to the Commission on Appointments for its appropriate action in the next plenary session, provided that no member shall be allowed to invoke the suspension of the consideration of the appointment in this regard. So again, pag na-disprove na bawal na. Pero pag nababypass naman, pwede pang ituloy-tuloy. And kapag ka naka 3 times na na-bypass, kailangan na i-call attention ng COA. Ano ba yung decision na dito? I-disapprove nyo ba or hahayaan nyo na yan? So pag hindi nila din disapprove, so yung appointment magiging final na. A regular appointment is made by the President while Congress is in session. It is made after, as a general rule, is made after nomination is confirmed by the Commission on Appointments, and once confirmed by the Commission, it continues until the end of the term of the appointee. Next is appointments made by the acting president and midnight appointments, which is prohibited. So midnight appointments are made by the president 2 months immediately before the next presidential elections up to the end of his term. Parang technique yan para i-appoint niya, para meron siyang kakampi, para pag wala na siya sa office, hindi siya tagtarin. Alam mo yun? Para may hawak pa rin siya kahit wala na siya sa office. This type of appointment is prohibited by the Constitution. The prohibition only applies to the presidential appointments and not to local elective officials for making last-minute appointments before the end of their tenure. So kung mayor ka lang naman, hindi ka naman president, pwede kang mag-midnight appointments. So midnight appointments bawal sa president. When midnight appointments are valid, for temporary appointments, it can be extended. Appointments only in the executive department, and it is necessary to make such appointment because continued vacancies will prejudice public service or endanger public safety. So, may cases niyan, di ba, ng midnight appointment. So, for example, kapag merong vacancy sa Supreme Court, then that's considered as urgent. Therefore, okay lang kasi if wala, then mapiprejudice. Limitations on appointing power. The members of the cabinet and their deputies and assistants shall not, unless otherwise provided in the Constitution, hold any other office or employment during their tenure. So, double or multiple offices is not allowed. The prohibition applies regardless whether either both appointments are merely temporary or in acting capacity, and the only exception for multiple offices are those provided for under the Constitution, such as the Vice President holding another position as a member of the cabinet as mentioned, and posts occupied by executive officials in ex officio capacity without additional compensations provided by law and is required by the primary functions of the officials' offices. So the spouse and relatives by consanguinity or affinity within the 4th civil degree of the President shall not during his tenure be appointed as members of the CONCOMs, members of the Office of Ombudsman, secretaries, undersecretaries, and chairmen, or heads of bureaus or offices including GOCCs and their subsidiaries. So inulit na natin yung kanina. Appointments extended by an acting president shall remain effective unless revoked by the elected president within 90 days from his assumption or reassumption of office. The power of the succeeding president to revoke appointments made by an acting president evidently refers only to appointments in the executive department. It has no application to appointments in the judiciary, because temporary or acting appointments can only undermine the independence of the judiciary due to their being revocable at will. President or acting president shall not make appointments except temporary ones to executive positions 2 months immediately before the next presidential elections and up to the end of his term, when continued vacancy will prejudice public service or endanger public safety, and the president shall have the power to make appointments during the recess of Congress, whether voluntary or compulsory, but such appointments shall be effective only until, again, disapproval by the Commission on Appointments until the next adjournment of the Congress. Next power is the power of removal or disciplinary power. It is an implied power derived from the power of appointment. But there are exceptions. So, general rule is kapag yung president nag-appoint, siya rin, dahil in-appoint niya, siya rin pwede mag-remove. Bakit appoint? Pwede mag-appoint si president. Kasi sa kanya lang naman yung executive power. So, dapat lahat sa executive department gusto niya. Dapat, hindi siya pwedeng pilitin na mag-work with someone na hindi nga gusto. Mahihirapan siya. Siya yung boss dyan Nasa kanya yung executive power. So, yung pwede niyang ibigyan ng posisyon, pwede niya ring tanggalin kasi siya yung nagbigay, siya rin pwede magtanggal. However, there are exceptions to that general rule. Those appointed by the president where the Constitution prescribes certain methods from separation such as impeachment. So, for example, pag nag-appoint siya ng justice sa Supreme Court, pag na-appoint na, touch move na yan, hindi niya na pwedeng tanggalin yung in-appoint niya sa Supreme Court. Judges of lower courts, likewise appointed by the president, are subject to disciplinary authority or may be removed only by the Supreme Court. Those elected local officials, of course. Hindi naman niya in-appoint yan Inelect ng tao yan In all other cases where the power of removal may be exercised only for cause as may be provided by law and in accordance with the prescribed administrative procedure. So, power of control and supervision. The president shall have control of all executive departments, bureaus, and offices. The president also has the power of oversight of a subordinate to ensure that the law and the rules are followed. So, yung control over all executive departments, bureaus, and offices, that's the power of control of the president. While the oversight of a subordinate is the power of supervision. So now let's discuss the doctrine of qualified political agency or the alter ego principle. Save in matters in which the Constitution or the circumstance requires the president to act personally, executive and administrative functions are exercised through executive departments headed by cabinet secretaries whose acts are presumptively the acts of the president unless disapproved by such president. So the executive secretary, when acting by authority of the president, may reverse the decision of another department secretary. The power of the president to reorganize the national government may be validly delegated to his or her cabinet members exercising control over a particular executive department. So now let's go to emergency powers. So Congress may authorize, so si Congress yung nag-authorize. Congress may authorize the president to exercise powers necessary and proper to carry out a declared national policy. It is submitted that on the basis of this provision, the president may be given emergency legislative powers if Congress so desires. So, conditions for the exercise of the president of emergency powers. First, there must be a war or a national emergency. Second, there must be a law authorizing the president to exercise emergency powers. Third, the exercise must be for a limited period only. Fourth, exercise must be necessary and proper to carry out a declared national policy. And fifth, must be subject to restrictions that Congress must provide. Such powers shall cease upon next adjournment of Congress unless sooner withdrawn by Congress. So what is the calling out power versus emergency powers? The calling out of the armed forces of the Philippines is to prevent or suppress lawless violence, and is a power that the Constitution directly vests in the president. So the president does not need congressional authority na kasi vested na sa kanya. Emergency powers, on the other hand, is power vested by Congress to the president to exercise powers necessary and proper to carry out a declared national policy during a state of war or national emergency. So unlike the calling out power, there must be a law authorizing the president to exercise emergency powers. Calling out, okay lang, walang law, pwedeng gawin ni president yan. Call out the AFP to suppress lawless violence. However, pag ibang emergency powers such as martial law, for example, then kailangan muna ng law authorizing the president to do so. So, Commander-in-Chief or military powers includes the calling out power, declaration of martial law, and suspension of privilege of writ of habeas corpus. Iba na yung martial law sa context ng 1987 Constitution sa time ni Marcos kasi iniba in response dun sa martial law na dineclare ni Marcos before. So, calling out power to call out the AFP to prevent or suppress lawless violence, invasion, or rebellion. Military tribunals are simply instrumentalities of executive power provided by the legislature for the commander-in-chief to aid him in enforcing discipline in the armed forces. The PNP kasi is in civilian in character, and a member of PNP is under actual jurisdiction of the civilian courts. The conditions of actual invasion or rebellion and the phrase public safety requires it need not concur before the president may exercise its calling out power. The only criterion is that whenever it becomes necessary sa discretion ng president na tawagin niya yung AFP for the purpose of preventing and suppressing lawless violence, invasion, or rebellion. So, at his discretion na pwede niyang i-call out yung AFP. The President as Commander-in-Chief has powers that are broad enough to include his prerogative to address exigencies or threats that endanger the government and the very integrity of the state. And the President has discretionary authority to declare a quote-unquote state of rebellion, and the court in a proper case may only look into the sufficiency of the factual basis of the exercise of the power. In determining the existence of rebellion, the President only needs to convince himself that there is probable cause or evidence showing that, more likely than not, a rebellion was committed or is being committed. Accuracy is not the same as sufficiency, as the former requires a higher degree of standard. Hindi kailangang accurate. But if at the discretion of the President, kailangan niyang i-call out yung AFP to suppress lawless violence, then so be it. Because he is, after all, the Commander-in-Chief of the AFP. So, to require the President to satisfy a higher standard, such as to require accuracy really, a higher standard of proof, that would in effect restrict the President's exercise of his powers. The declaration of martial law. The Constitution grants to the President the discretion to determine the territorial coverage of martial law. Hindi pwedeng, pag sabi martial law, pwedeng sa certain area lang, like gusto ginawa na Mindanao lang, or parts of Mindanao lang. Hindi kailangan buong Pilipinas. And the suspension of the privilege of writ of habeas corpus also, nasa discretion ng President kung ano yung territorial coverage. He or she, however, the President may put the entire Philippines or just a part thereof. It's his discretion. The President may place an area in martial law for a period not exceeding 60 days, following which it shall be lifted unless extended by Congress. So the grounds for declaration is that there is invasion or rebellion in his discretion when public safety requires it. However, the President now has a duty to report to Congress such declaration within 48 hours, personally or in writing. Kasi unlike calling out power, in the exercise of emergency powers such as declaration of martial law and suspension of the privilege of writ of habeas corpus, kailangan ng authority or law galing sa Congress. The Congress, if not in session, shall within 24 hours following such proclamation or suspension convene in accordance with its rules without any need of calls. Pwede siya magtawag pero kailangan niyang i-inform si Congress. The Congress then, bakit pwede na siyang magtawag before? Hindi siya yung tatawagan muna si Congress or magsusulat muna siya kay Congress and kailangan muna ng approval ng Congress bago niya i-exercise yung emergency power. Hindi. Pwede niyang i-exercise agad. Kasi, sometimes, time is of the essence to address an issue. Diba? So, pwede ka nang i-ano diyan and then, i-inform niya yung Congress and then later, the Congress has the authority to revoke or extend. Pero, after na. To address an exigency. Now, after i-assess ng Congress, pwede niyang i-revoke kung tingin niya mali. Pwede niya ring extend yung effectivity of proclamation by a majority vote of all its members voting jointly in regular or special session. Regular session if it's in session, special session if not in session nangyari. The Constitution does not specify the number of times the Congress is allowed to approve an extension of martial law, so pwedeng unlimited as long as kailangan. And the Congress has prerogative to extend the martial law, and the Constitution does not limit the period for which it can extend the same. Limitations to exercise congressional authority to extend proclamation of martial law. The extension should be upon the President's initiative, pero yung final say of course nasa Congress, and it should be grounded on the persistence of the invasion or rebellion and demands of public safety. Dapat justifiable, and it is subject to the court's review of the sufficiency of its factual basis upon petition of any citizen. So, pag medyo parang weird na, di ba? Pwede kasing magkasundo si Congress at si Presidente. Any citizen, pwedeng sa court na parang, but may basis pa ba para ipagpatuloy yung martial law? Parang wala na, di ba? Kasi nire-restrict yung rights ng citizens kapag may martial law. So, pwede i-petition yung court, and the Supreme Court has the authority to inquire into the sufficiency of the factual basis of declaration of martial law or the suspension of the privilege of writ of habeas corpus, as the case may be, at the instance of any citizen. Decision must be promulgated 30 days from its filing. The court can simultaneously exercise the power of review with and independently from the power to revoke or extend of Congress. Corollary, any perceived inaction or default on the part of Congress does not deprive or deny the court of its power to review. Ways to lift martial law or suspension of privilege of writ of habeas corpus is if it's lifted by the President himself, by operation of law, after 60 days at hindi in-extend ng Congress, revocation by Congress, and nullification by the Supreme Court if walang factual basis. So, checks and balance to. Now, suspension of the privilege of writ of habeas corpus. The Constitution grants the President the discretion to determine territorial coverage of the suspension of the privilege of the writ of habeas corpus. The President may suspend the privilege of the writ of habeas corpus for 60 days, following which it shall be lifted unless extended by Congress. So, yung effects of suspension of the privilege of writ of habeas corpus suspends the issuance of writ of habeas corpus, which is the remedy against illegal arrests and detention. The proclamation, however, does not affect the right to post bail. Suspension of privilege of writ applies only to persons facing charges of rebellion or offenses inherent in or directly connected with invasion. Persons arrested must be charged within 3 days. If not, they must be released, and suspension of the privilege of writ of habeas corpus does not supersede civilian authority. Okay, ilang powers pa? Madami pa ang powers. Okay, let's try to finish it in one video. I'll try. If not, then I'll create a part 2. So now let's go to the pardoning power, or power of executive clemency. The President may extend executive clemency for criminal and administrative penalties. The Constitution does not make a distinction as to the extent of pardoning power except with respect to impeachment cases. So what are the forms of pardon or executive clemency? Reprieve, commutation, pardon, amnesty, and remission of fines and forfeitures. So when you say reprieve, it's the postponement of execution of a sentence to a certain day. Commutation naman, postponement only. Commutation is a remission on the part of the punishment of a part of a punishment, so babawasan, a substitution of a lesser penalty for the one originally imposed, and it is the reduction or mitigation of the penalty. Pardon is an act of grace, proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed from the punishment the law inflicts for a crime he has committed. It is discretionary on the part of the President and may not be controlled by legislature or reversed by the courts, unless there is a constitutional violation. Any act of Congress by way of statute cannot operate to delimit the pardoning power of the President. However, merong limitations, such as if it is in a case of impeachment, if it's a violation of laws without favorable recommendation of the COMELEC, if it's granted only after conviction by final judgment, except if it's an amnesty, if it, it can only be granted after final judgment. Kasi, ba't ka magpapardon hindi pa naman guilty or wala pa namang anong pinapatawad mo, 'di ba? Innocent until proven guilty, dapat final judgment saka ka pwedeng magpardon. Bawal mong i-pardon before the final judgment. Cannot be granted in cases of legislative contempt or civil contempt kasi disrespect yun sa department, so parang encroachment. Cannot absolve convict of civil liability, agad criminal liability and administrative liability lang. Cannot restore public offices already forfeited. Exception is if a pardon is given because he was acquitted on the ground that he did not commit the crime. Reinstatement and back wages would be due. Plenary pardon extinguishes all the penalties imposed including accessory disabilities. Partial pardon naman, may iba ka lang na tinanggal. So it does not extinguish all penalties. Absolute pardon does not impose any condition upon pardon kasi pwedeng conditional pardon eh. Pag sabi mo conditional pardon, it's the effectivity of the pardon is subject to conditions which the offender must first fulfill. It has no force until accepted by potential pardonee who has the right to reject it. Or, violations. Like, for example, tinanggap mo yung pardon pero pag ginawa mo yan, then you violated your pardon and then therefore you have to suffer the consequences. Amnesty commonly denotes a general pardon to rebels for their treason or other high political offenses, usually political offenses. So, or the forgiveness which one sovereign grants to the subjects of another who have offended by some breach the law of nations. Amnesty looks backwards and abolishes and puts into oblivion the offense itself. So overlooks and obliterates the offense with which he is charged, that the person released by amnesty stands before the law precisely as though he had committed no offense. Kasi kapag pardon, merong offense, pinatawad lang. Pag amnesty, talagang obliteration. A grant of amnesty by the President must be with concurrence of a majority of all the members of Congress. So, yung iba, pardon, reprieve, commutation, President lang. Pero pag amnesty, since obliteration talaga siya, kailangan na ng concurrence of majority of members of Congress. Remission of fines and forfeiture merely prevents the collection of fines or the confiscation of forfeited property. It cannot have the effect of returning property which has been vested in third parties or money already in public treasury kasi mapaprejudice naman sila in that case. So, bakit may pardoning power yung President? Forgiveness. It's his discretion. Unbridled ba? Yes. But, paano pag in-abuse niya? Then, it's up for the people to decide. Diba? The President answers to the people naman and he is very concerned sa public opinion. So, dun magkakatalo sa public opinion. Kasi, i-judge din naman siya ng tao based sa kung sino pinapardon niya at bakit siya nagpardon, diba? Borrowing power. The President may contract or guarantee foreign loans on behalf of the Republic with the concurrence of the Monetary Board, subject to such limitations as may be provided by law. The Monetary Board shall submit to Congress a complete report on loans within 30 days from the end of every quarter. Now let's go to diplomatic power. The President's diplomatic power is inherent in his position as the head of state. So the President, wala tayong Prime Minister eh. Sa ibang bansa, meron silang head of state, meron silang head of government, which is the Prime Minister. Sa atin, head of state, head of government, si President both. So, kung may monarchy, head of state, usually nag-represent sa foreign affairs is the monarchy, and then yung Prime Minister, yun yung sa government. So, sa atin, vested yung diplomatic power sa President. He has the power to make treaties, appoint ambassadors, public ministers, consuls, receive ambassadors and other public ministers duly accredited to the Philippines, and has deportation power. Treaty-making power and ratification. The power to negotiate, enter, and ratify international treaties is vested in the President, subject to the concurrence of the Senate. No treaty or international agreement shall be valid and effective unless concurred by at least 2/3 of all members of the Senate. Agreements, iba yung executive agreement sa treaties. Yung treaties kailangan may concurrence para maging valid. Agreements that are permanent and original should be embodied in a treaty and need Senate concurrence. Agreements, however, which are temporary or merely for implementation of treaties or statutes already in force, do not need concurrence. The President can enter into an executive agreement without concurrence of the Senate. So, Senate, hindi Congress yung nagko-concur. The right of the executive to enter into binding agreements without the necessity of subsequent Senate approval has been confirmed by long usage. However, the President may not by executive agreement enter into transaction which is prohibited by statutes enacted prior thereto. Under the Constitution, the main function of the executive is to enforce the laws enacted by Congress. So, authority of President to withdraw from treaties of international agreements. The court adopts the following guidelines as a modality for evaluating cases concerning the President's withdrawal from international agreements. The President enjoys some leeway in withdrawing from agreements which he or she determines to be contrary to the Constitution or our laws. The President cannot unilaterally, however, withdraw from agreements which are entered pursuant to congressional imprimatur. The President cannot unilaterally withdraw from international agreements where the Senate concurred and expressly declared that any withdrawal must also be made with its concurrence. Now let's go to budgetary powers. So within 30 days from the opening of every regular session, the President shall submit to Congress a budget of expenditures and sources of financing, including receipts from existing and proposed revenue measures. The Congress may not increase the appropriation recommended by the President for the operation of the government as specified in the budget. The form, content, and manner of preparation of the budget shall be prescribed by law. This power is properly entrusted to the executive department, as it is the President who, as chief administrator and enforcer of the laws, in the best position to propose the corresponding appropriations, therefore, on the basis of existing or expected sources of revenue. The informing power, the President shall address Congress at the opening of its regular session. He may also appear before it at any other time. The information may be needed for the basis of the legislation. So the President usually discharges the informing power through what is known as the State of the Nation Address or SONA, yung tinatelevise. Residual power. The powers of the President are more than the sum of the executive powers expressly enumerated in the Constitution. He also exercises all powers which are not clearly legislative or judicial. The duty of the government to serve and protect the people, as well as to see the maintenance of peace and order, the protection of life, liberty, and property, and the promotion of general welfare is the basis of existence of residual unstated powers. So ito na yung parang umbrella na other powers as long as it does not fall sa province ng judicial department or legislative department, then most likely it is an executive power. Veto powers. General veto. If the President disapproves a bill, so diniscuss na natin itong veto powers sa lawmaking process, sa legislative. If the President disapproves a bill enacted by Congress, he or she should veto the entire bill. He or she is not allowed to veto separate items of the bill. Pero merong item veto. The President may, however, veto separate items of an appropriation, revenue, or tariff bill without vetoing the entire bill. So yun lang yung tatlo na pwede item veto. Partial veto is invalid except where item veto is allowed, because the general rule in the exercise of veto power is that it's generally all or nothing. The exception is an item veto when it comes to appropriation, revenue, or tariff bills, because the government needs the money to run its machinery and it cannot veto the entire bill even if it may contain objectionable features. The intent of an item veto is to prevent the legislature from forcing the President to veto an entire appropriation bill, thereby paralyzing the government. So lastly, yung other powers. So call Congress to a special session at any time, approve or veto bills, power to deport aliens, discuss na din naman, consent to deputization of government personnel by COMELEC, discipline such deputies, exercise tariff powers by delegation of Congress or flexible tariff clause, and power to classify or reclassify lands, very important. So last, rules of succession. Okay, succession. Anong mangyayari? So, kunwari yung President-elect dies, of course, the VP-elect becomes President. Kapag yung President-elect na disable, ganun din. VP-elect becomes President. Kapag nag-fail to qualify, so, VP-elect shall act as President until President-elect becomes qualified. Kapag hindi napili yung President-elect, VP-elect shall act as President until a President is chosen and qualifies. Pag both yung President and VP not qualified, chosen, or both sila namatay or permanently disabled, the Senate President, if hindi pa rin Senate President, Speaker of the House. So, yun yung magiging acting President until a President or a VP shall have been elected, chosen, and qualified. When all officials mentioned, si President, si VP, si Senate President, si Speaker of the House, na matay, na-incapacitate, or unable to assume office. There's a series na ganyan eh. Nakalimutan ko yung title, Designated designated something designated survivor series siya na parang siya yung na-designate. Congress will decide by law who will act as president until a president or VP shall have been elected and qualified. Yung sa atin wala tayong designated pero there's Congress can enact a law if that happens. Like, parang first up, binomba yung Malacanang namatay silang lahat doon during SONA. Mga ganun. An acting president is not the incumbent president or does not become president to serve until the unexpired portion of the term. When the Senate president or speaker becomes acting president, he or she does not lose a position as Senate president and speaker of the House, pero simultaneously niyang hahawakan both. So, pagka, yun yung situations kapag vacancy occurs at the start of the term. Kapag ka in the middle of the term naman, and the president-elect dies, or becomes disabled, or unable to discharge duties, or na-resign, or impeach in the middle of the term, the VP becomes the president. Hindi siya acting lang. Kasi kapag ka start of the term, pag nangyari to, the VP, pag die, then VP-elect becomes president. Pero, pag nag-fail to qualify or not chosen, then parang acting lang muna si VP. Hindi niya i-assume pa. Pag sa middle of the term, pero syempre pag namatay na, assume niya agad kahit sa start of term. So, pag sa middle of the term, magiging president si VP. If both president and VP dies, or is disabled, resigns, impeached, permanently unable to discharge duties, yung same, Senate President, if unable, Speaker of the House, act as President until President or VP has been elected and qualified. So, pag hindi pa patay yung VP, siya na magiging President. Pero pag unable na rin si VP, walang President, unable na rin si VP, acting si Senate President or una Senate President, kung hindi pa rin Senate President, may hierarchy siya. Speaker of the House. Pag, temporary lang kasi kailangan pa rin magpa-elect ng President VP. Acting President dies or becomes incapacitated or unable to assume office, then Congress will decide by law. So, Vice President, if a vacancy occurs in the position of VP, the President shall nominate a VP. Kung buhay si President pero walang VP, si President pag-nominate ng VP among members of Senate and House of Representatives, who shall then assume office upon confirmation by majority vote of all members of both houses of Congress voting separately, so hindi kailangan pa special election. Procedure in case of vacancies in the office of both President and Vice President. Congress shall convene in accordance with the rules without the need of call on the third day after the vacancy occurs. Within 7 days, it shall enact a law for special election to be held not earlier than 45 days nor not later than 60 days thereafter, unless again 18 months na lang magkaka-election na presidential election. The bill is certified, becomes law. Upon its approval in third reading, appropriations shall be charged against current appropriations. Convening of Congress cannot be suspended, nor the special election postponed. Succession in case of disability. In case President transmits to the Speaker of the House and Senate President his written declaration of inability to discharge the powers and duties of his office, yung VP magiging acting President until, kapag temporary, until the President transmits a written declaration na okay na siya. In case of majority of cabinet members transmit to the Speaker of the House and President a written declaration of President's inability to discharge, yung hindi galing sa President but galing sa cabinet members na unable si President to discharge the powers and duties of his office, the VP shall immediately assume the powers and duties as the acting President. So, if may contradictory declaration, sabi ng President capable siya, sabi naman ng cabinet na hindi, Congress shall decide the issue and the Congress shall vote by 2/3 of both houses voting separately regarding the President's incapacity. Kapag katalo si President, of course, the VP shall act as President. Otherwise, the President shall continue to exercise the powers and duties of his office. In case of serious illness or incapacity of the President, the public shall be informed of the state of his health. The members of the Cabinet in charge of national security and foreign relations and Chief of Staff of the AFP shall not be denied access to the President during such illness. So that's it for the Executive Department, just one video. And yung next is Judicial Department. Sige, parang one video na rin, I guess. Yung sa Judicial Department. Mahaba lang talaga kasing legislative eh. And then after Judicial Department, Concoms. Also one video. And then let's go to CONSTI2, Bill of Rights. So, see you.